Good afternoon, everybody. Welcome to another live question and answer session. My name is Samara Belitzky. I am a lawyer at Samfiru Tumarkin, and I am based out in Ottawa, but I assist clients all over Ontario and all over BC. I will be here, as I usually am, every about second Friday to answer your questions related to employment law, any workplace issues, severance, terminations, issues with respect to changes to the terms and conditions of your employment, issues related to sick leave, medical leaves of absence, whatever the case may be. If it's related to your employment or your workplace, I'm here to answer your questions. So send your questions in. As I said, I'll be here for the next half an hour or so to answer all of your questions. I always have a couple of things prepared to discuss while we wait for some questions to roll in. So not unlike many of the sessions I've done over the last couple of months, unfortunately, yet again, there's been another big announcement of mass layoffs this week. So I was hoping to start off with something different today, but that has been kind of prominent in the news and we've been getting questions about it. So I once again wanted to address mass terminations or mass layoffs very quickly. I wanted to mention as well, if you do have questions about a mass termination or a mass layoff more specifically, whether it's yourself going through something like that or someone you know, send your questions in. The last session that I did, even though we did kind of address it in a more generic way at the beginning of our session, we did end up getting a lot of questions about mass layoffs throughout the session and throughout the question and answer seminar that we did. So please send your questions in if you have a specific situation. Every single situation is different. We do our best, to give you some information that would apply generally to most situations, but no two situations are alike. So if you do have a specific situation where you're being let go, if it's a mass termination, do send in your question, and I will get to as many as I can. I do have a couple questions coming in. So before I get to the questions, I'll just touch on mass layoffs very, very quickly so that we can address just the important points. So in terms of mass terminations or mass layoffs, what's important to know is that the only thing that's different compared to an individual termination is your bare minimum termination entitlement. So as an employee, if you're let go, as the only employee that's being let go, your bare minimum entitlements under the employment standards legislation in the province that you're in will be less than if you're let go as part of a larger mass termination of 50 or more people. When you're in let go as part of a mass termination or mass layoff of 50 or more people, then you will be entitled to a higher or an increased amount for your bare minimum termination entitlements under the employment standards legislation. That's the main difference. So no matter what the case is, if it's an individual termination, a mass termination, or layoff, you're going to be owed severance no matter what, unless the company has declared bankruptcy, which we did see with Nordstrom recently. But most of the time, the company will not have declared bankruptcy, will not be in receivership, and so you would be owed your severance. Now, I mentioned that the main difference is that you would be owed more as your bare minimum. You would still have a right to your full severance, whether you're part of a mass termination or an individual termination, or perhaps a termination of only a few people. Your full severance entitlements will not change. And when I'm talking about full severance, what I'm talking about is your severance that's based on the law that comes out of the court, that's based on your age, your length of service, your job. So we do an analysis of different factors in order to estimate what your full severance would be. Most people are entitled to your full severance. So for the vast majority of people, your bare minimum under the Employment Standards Act will just be your starting off point. And so it's important when you're in the middle of a mass termination or a mass layoff that you know that, yes, you are entitled to more under the Employment Standards Act as your bare minimum, but for most people, that will be just your starting off point, and you will be owed quite a bit more severance than the bare minimum. And that's why it's always important to get in touch with an employment lawyer and find out what your total severance would be, what your full rights would be when it comes to a termination before you accept or sign anything. Once you sign something, you will be stuck with it. So definitely get in touch with us, whether you're going through a mass layoff or termination or any kind of termination. It's always important to get in touch with an employment lawyer and have them review what you're being offered before you sign anything. And you can contact us by phone. The number's on the screen right now. You can contact us at help@employmentlawyer.ca. You can also visit our website at employmentlawyer.ca. We have a lot of resources on our website that you can access. We have lots of articles about mass terminations and mass layoffs, depending on which province you're in. So you can definitely look that up, but it's no substitute for speaking to an employment lawyer and getting specific legal advice for your situation. So I'm going to get to the questions that we have coming in. I have a question from Vera on Facebook who asks, can your employer refuse to provide you with an ROE, a record of employment? I was let go after almost 10 years, but he says I was a contract worker and so I don't need one from him. Okay, so generally speaking, an employee or an employment relationship comes to an end, yes, the employer has to issue a record of employment. It's the law. There's no way around it. It's a legal obligation. If, let's say, the employer is refusing to issue a record of employment, you can get a lawyer involved. You can also get Service Canada to itself to follow up with the employer. So I've had lots of clients who, for example, the employer hasn't issued the record of employment, and I have a client who's trying to access EI benefits. Oftentimes, Service Canada, if you contact them directly, will actually contact the employer and follow up with the employer to get them to file a record of employment so that they can process the EI benefits claim. So that's something that you can have Service Canada do, which is free. It's something that they do as part of their responsibilities of processing employment insurance benefits claims. But again, it is the law. There's no way around it. The employer has to issue a record of employment. In the scenario that you're describing, Vera, your employer or the company that you work for, depending on whether you are an employee or not, is basically taking the position that you're not an employee. If you're not an employee, then the record of employment would not have to be issued because record of employments are only for employment relationships where it's employee-employer. So your employer here is saying you're not an employee, you're a contractor. That remains to be seen. If you've worked with this company for 10 years, if it's the only company you've worked with, you've had the vast majority of your income come from this company for 10 years, and certain other factors that we look at as well, the odds are that you would be an employee, or you could also be a dependent contractor. So there are actually 3 categories of workers. Most people know about the 2, employee versus independent contractor. There's actually a 3rd category in the middle called a dependent contractor. A dependent contractor is a contractor, but when you're in a situation where you're dependent on one company for the vast majority of your income, you could be considered a dependent contractor. And in that case, whether you're an employee or a dependent contractor, you would still be owed severance when you're let go from your job. So there wouldn't be any difference between, whether you're an employee or a dependent contractor, your severance rights will be the same. If you're an independent contractor and you're truly an independent contractor, then you wouldn't be owed severance, and you wouldn't have to have your employer issue an ROE, a record of employment. So Vera, what it'll come down to here is whether you are an employee or a contractor, a dependent contractor. What you'll need to do is get in touch with us. You need to have an employment lawyer review your situation in order to determine what type of worker you were. What is your worker status? That will then determine if the company has to issue a record of employment, of course, but more importantly, whether you're owed severance. Because if they're treating you like a contractor, the odds are they haven't offered you any severance. And if you're an employee or a dependent contractor, you are owed severance. So definitely get in touch with us. You can contact me directly. You can go to our website at employmentlawyer.ca. You can click on my profile, access my contact information, and contact me directly. Call me or send me an email, and I can look at this situation in further detail with you to figure out what you are in terms of a worker status, and then we can pursue whatever it is that you're owed. And this is a common issue. We see it all the time where people have been misclassified. It's a very common misconception that people think that if you've signed a document that's called an independent contractor agreement, where it says that you are an independent contractor, that means you're an independent contractor and there's no two ways about it. And that's not actually how the law works. The way the law works is when we're assessing or determining whether somebody is an employee or a contractor, whether dependent or independent, we look at the actual employment relationship. We look at the terms and conditions of the employment. How much control does the company have over the worker? What's the degree of control? Are you setting your own hours? Is the company setting your hours? Are you setting your own pay, or is the company setting your pay? Have you worked for the same company and nobody else for a very long time? So there's all different things that we look at that will help us determine what the true nature of the relationship is. It's not the written agreement. It's not a document you sign that says you're an independent contractor. It's not the way you file your taxes. There's actually many, many other factors that we look at that determine what the status is of a worker. So if you're in a situation where, you've been told you're an independent contractor, you're not sure, you signed something that says you're an independent contractor, doesn't mean that you are. It's really, really important to get employment advice from an employment lawyer to determine your situation. I can't tell you how many times I get contacted by people who say, I think I'm an independent contractor, I've signed an agreement, this is the situation. And then when we look deeper at the actual relationship, it's very, very clear that this person is an employee or sometimes a dependent contractor and that they're owed severance. Sometimes I have clients who've worked for one company for 20 years and they're let go without any severance at all because the company considers them to be a contractor when really they're an employee and they're owed a lot of severance. So you never can be too sure. It's very important to always get everything reviewed by an employment lawyer, get it assessed in detail so that you know exactly where you stand and what you're owed. I have a question from Jonathan K on YouTube who says, after working from home for 2 years, my employer is changing my in-office requirements. How can this be fought? Okay, so this is a question we're getting a lot lately. You may have seen in the news, for example, RBC this week announced that they're going to be requiring employees to be returning to the office 4 days a week. It's really important to know that if before the pandemic, you were working in the office, part of the terms and conditions of your employment were that you are working in the office every day, then that is a term of your employment that the employer can continue to enforce. So during the pandemic, if you were working remotely, it was basically on an understanding that it was temporary in nature. And so now that the pandemic has improved, the employer does have the right to essentially force you back to the office or the workplace and have you go back to those regular permanent terms of employment that are applicable and that applied prior to the pandemic and prior to working remotely. In a case like that, there isn't anything that you can do in terms of refusing that. Certainly you can refuse to go back to work in person. However, if you do that, it could be considered insubordination, and it could also be considered a resignation. So if you're refusing to report to work and the terms and conditions of your employment basically force you to go to work because that's what your terms and conditions always were, then you have to go to work. If you don't go to work, then you're engaging in insubordination, and your employer, I should say, could actually terminate you for cause without any notice, without any severance for insubordination. The other thing the employer can do is take the position that you've abandoned your job if you're not showing up to work. And in that case, it would be job abandonment or resignation, and you wouldn't be owed any severance. So it's a situation where if that is your situation, you were working in the office or in your workplace prior to the pandemic, you were working remotely for the pandemic as a temporary nature or a temporary measure, and the employer is now saying you have to go back, there is no way around that from a legal perspective. Certainly, you can speak to your employer, you can see if they're open to other arrangements, you can propose things to them and see if you can come to some sort of mutual agreement. nothing prevents you from doing that. But from a legal perspective, you don't have legal recourse against your employer for basically enforcing your regular terms of employment. Now, in contrast to that, if you were actually hired during the pandemic as a remote worker, and either your employment contract says that your work location or your place of work is remote, then you would be able to push back on your employer saying that you have to come into the office because you did not have an established term of your employment as being something where you have to work from the workplace or from the office. So in that scenario, the employer does not have the right to make that significant change to the terms of your employment without your consent. Now, again, this is specifically for people who were hired during the pandemic and have an employment contract that says that their work location is remote or their workplace is remote. It also could apply to people where their employment contract is silent and workplace location was never discussed. That is something that also could give an opening to push back on being required to go into the office or go into the workplace. So those are kind of the exceptions where people were hired during the pandemic. But again, if you were hired before the pandemic and part of the terms and conditions of your work were to work from a workplace from the office, the employer is within their rights to have you then go back to those terms and work from the office. I have a question from George on LinkedIn. Who says, today's my last day with my employer. I gave in my resignation. It's a non-unionized workplace. My quarterly bonus pays out next month. However, I was wondering if I was entitled to any of it since I've worked almost the whole first quarter. So in terms of, generally speaking, if you resign before the bonus is paid out, you likely will not be entitled to receive that bonus. Okay. But it will depend on the terms and conditions of the bonus plan. So if there's an actual bonus plan in place, a written policy with respect to how the bonus works, there may be a provision in there that addresses resignation or the end of employment and how it works if you resign where you worked, for example, as you said, most of the quarter, and then you've resigned. What happens? Do you get a prorated bonus? Do you get nothing? There might be a provision in there. Absent a provision that specifies it, generally speaking, you won't be entitled to anything that gets paid out after your resignation. And that's specific to resignations. If, for example, it was a termination of your employment, then in most cases you would be entitled to receive the bonus. There are exceptions to that, and it does depend on the circumstances. But in most cases, the law says you would have to get the bonus if you're let go, and it's paid out, immediately after your termination. But for resignations, it works differently. So, George, take a look, see if there's a policy. Maybe ask HR if you're not sure about it. Ask HR if there's a policy. If there is, have them send it to you. And then if it's not clear to you based on reviewing the policy, certainly you can get in touch with us. We can review it for you and see if there is anything there that can assist you in getting the bonus. Obviously, you want to get the bonus. You worked, most of the quarter and you want to receive it. But from a legal perspective, there may not be a right for you to receive it. So take a look at the policy and then go from there. So I have a question here from Stephen on Facebook who asks, can you be forced to relocate? My company is restructuring and we're being told our department is shifting to a new office, but it's almost an hour away. So the short answer is you cannot be forced to relocate if it's a significant distance away. And this is something that applies to all changes to terms and conditions of employment. So when we're dealing with an employer making unilateral changes, so changes without an employee's consent to the terms and conditions of employment, there is a certain amount of change or a certain level of change that can be made. The employer does have the discretion, but it cannot be a significant change to the fundamental terms of employment. And what we mean by that is, for example, cutting your salary by 30% or cutting your hours, which will then reduce your compensation. or moving your office, for example, 3 hours away. So there are certain terms and conditions that the employer cannot impose on you. And so if, let's say, an employer does impose a significant change to the fundamental terms of your employment, you do have the ability to push back, and you can assert what's called a constructive dismissal claim. And essentially what that means is that the change that's being imposed upon you is so significant that you can't possibly continue working under those changed terms. And so it's akin to a termination, because the employer is not outright saying you're fired, but these circumstances lead to the same result, where it's simply the employment relationship simply cannot continue. And so with respect to relocation specifically, it depends on what the increase to your commute will be. So if, for example, the office is being moved or the workplace is being moved and your commute each way is going to increase by 20 minutes, that is not going to be considered a significant enough change for you to be able to push back and possibly claim constructive dismissal. If, for example, the change is that it's going to take you an additional hour each way on top of your regular commute, it's an extra hour each way, that would be considered a significant enough change, and you could push back on that. You don't have to accept a change of that nature. And if push comes to shove and the employer is insisting on it, you could essentially assert a claim for constructive dismissal. Now, when you're doing anything of this nature, when you're assessing a change, whether it's significant enough or not for you to push back, whether you have to accept it, what you do next, how you refuse it, you have to do it with the assistance of an employment lawyer. These are the stages when you're dealing with these changes where it could make or break your ability to pursue this type of claim. So you want to make sure that you're consulting with an employment lawyer and getting assistance on how to go through this process to make sure that you have the strongest case possible. So for you specifically, Stephen, if you are being told you have to go to a new office, first of all, the employer does have to give you notice of this change in writing. So you would have to be told on X date, this is where your new workplace will be. And then you'll be able to assess what the distance is, what the commute time will be, and see how much of an extra commute it will be. I know you said it's an hour away, but I don't know what your current commute is. So if your current commute is, 40 minutes and then it'll be an hour, an extra 20 minutes, as I said before, is not going to be a significant enough change. So we look at it from comparing your current commute time to what your commute time will be once the change takes place. And that's how we determine if it's significant or not and whether you can push back on it. So I would recommend, Stephen, that you get in touch with us. You can contact me directly. You can contact our firm. We can assess the situation for you and see if it's a significant enough change. If it is, I'd be very happy to help you kind of navigate this situation. With relocation, sometimes it's tough because if it's a change to your duties or a change to your title, for example, oftentimes you can work with an employer to figure out a way forward for everybody. If it's a relocation and it's significantly far away and that's not going to work for you as an employee, there isn't really a middle ground there. It's either you go to that new place or it's a termination and your employer owes you your full severance. Those are really the choices when we're dealing with relocations. And oftentimes companies and employers are not actually aware of how the law works on these points. So it's not that, they know that they're not allowed to do it and they're doing it anyway. Sometimes that is the case. But a lot of times when I'm dealing with these issues, the employers actually don't even realize what they're doing is, something that they don't have the right to do and that they need the employee's consent for it. So in any case, it's really important to speak with an employment lawyer to move forward using the proper steps and to really protect yourself. So definitely get in touch with us, Stephen, and we can help you move forward from here. So I have a couple of questions from JR on YouTube regarding staffing or temp agencies. So JR is asking about whether there's a website that lists all the different staffing or temp agencies. No, there's not, to my knowledge, a website of that nature. And then I also have the question from JR asking if I can explain the difference between a staffing agency and temp agency and how it relates to full-time status as an employee inside an organization. I'm not sure exactly what you're asking, JR. Usually staffing agencies and temp agencies, as you're referring to, where agencies are placing people with companies on a temporary basis. Those are usually interchangeable terms and they mean the same thing. It's companies that help place workers with companies who have vacancies. So I'm not sure that I understand your question with regard to full-time status as an employee inside an organization. What I can tell you is that in certain circumstances, if let's say you are placed through a staffing agency or a temp agency with a company and you work for that company for, let's say, 10 years, you're paid through the staffing agency, but you're basically an employee of the company. You have a title, you're in their organizational structure, you report to a manager at the company, you have a company email address, and so on and so forth. Oftentimes in that case, there can be an argument made that you're actually an employee of that company, not of the staffing agency. But it also can depend on what you've signed. Oftentimes when you're signing with a staffing agency, you do sign a contract that has very specific provisions about who will be your actual employer, and how that would work in the case of a termination. So you have to be very careful when you're dealing with these agencies in terms of what you sign. I've oftentimes reviewed these types of contracts for people. If ever you need a contract reviewed, whether it be a staffing agency or temp agency employment agreement, which is usually kind of its own beast, its own thing that we would have to review versus a regular employment agreement. But at the end of the day, they're all employment agreements, and it's really important to get them reviewed by an employment lawyer before you sign, because you don't know what it is otherwise that you're getting yourself into. You don't know what it says. You might think you know, you might read it and think you understand, but oftentimes there's language used that really only an employment lawyer will understand the consequences of. So you have to be very careful, especially when dealing with staffing agency, when signing an agreement, because they tend to contain very exceptional and specific provisions that you have to be very wary of. JR, if you do have any specific questions, if you're dealing with an actual situation that just wasn't outlined in your question, feel free to contact us and we can go through the situation with you in more detail if you're having some challenges with either a staffing agency or a company that you're working for. We've given the information, but you can email at help@employmentlawyer.ca or just go to our website, employmentlawyer.ca. All of our contact information is there, so you can always contact us that way. We're just towards the end of our session today. I'm just scrolling here. I think I got to most of the questions. If I didn't get to your question, you can always join in on Monday for the next session that we have with one of my colleagues and send in your questions there. Otherwise, feel free to contact us any of the other ways we've talked about today if you do have an issue that you want help with or you have a question for us. So thank you very much, everyone, for tuning in today, and I hope that everyone has a wonderful weekend. Bye-bye.